Duty of LL to deliver possession. In general, landlords owe tenants a duty to deliver possession. Although the traditional rule required only the delivery of constructive possession, such as by providing a key to the property, most states follow the modern rule of requiring the delivery of actual, physical possession. LL duty to make repairs. Landlords in residential leases also generally have a duty to make repairs. Even if a lease places this duty on the tenants, courts will still find that it rests with the landlord. Landlords are permitted to engage professionals to make repairs. There is no obligation that they do so themselves. Covenant of quiet enjoyment. Landlords also generally are required to comply with the covenant of quiet enjoyment. This doctrine requires that landlords not interfere or permit others, such as other tenants in a multi-unit property, to interfere with one's right to use, possess, and enjoy their possessory interest. A tenant that has suffered a breach of this covenant must give notice to the landlord to take remedial action. Failing any remedial action, the tenant is permitted to give notice of her constructive eviction and cease paying rent. Implied warranty of habitability. Residential leases only are subject to an implied warranty of habitability. This requires that the landlord deliver the property in a condition fit for ordinary residential use. This implied warranty generally requires landlords to provide electricity, heating, hot and running water. A tenant must give notice to the landlord if a breach has occurred, and they may either refuse rent during the period of breach, make repairs and deduct the costs from their rent, or vacate the premises until remedied. Duties of tenant. In general, a tenant has two key duties: pay rent and not commit waste. Waste. First, Lois may argue that Tammy committed waste by failing to inform her of the second time the hot water failed. There are three types of waste: affirmative, tenant intentionally destroys or reduces value of property; permissive, tenant's negligence causes damage or otherwise reduces value of property; and ameliorative, tenant alters the property, even in an economically valuable way, without landlord's permission. Rent. As noted, a tenant has the duty to pay rent. As discussed above, however, there are instances in which a tenant may refuse to pay, reduce, or otherwise withhold, such as in an escrow account, rent. Tenancy for years. The facts indicate that Lois and Tammy entered into a lease or tenancy for years. Despite its name, this lease is simply a lease for a fixed period, such as 9 months in this case. Leases, because they are interests in real property, must generally be in writing to satisfy the statute of frauds even if under 1 year in length. This lease is different from a periodic lease, such as month to month, because it has a definite endpoint that the parties have agreed upon. Termination of lease. A tenancy for years will automatically terminate at the expiration of its term. Continued tenancy following the lease can give rise to a periodic tenancy or a holdover tenancy. A lease can also terminate through an action for eviction or by mutual agreement of the parties. Lois is required to mitigate damages by taking reasonable steps to rent out the property once Tammy leaves, but Lois will not be responsible if she cannot find a suitable renter after taking reasonable steps. Surrender. When a tenant breaks a lease and surrenders, it generally must be in writing if the lease term was over 1 year. Because this lease was for only 9 months, the surrender did not need to be in writing. Statute of frauds. The statute of frauds requires that contracts creating interests in land, including leases over 1 year, must be in writing. Express easement. An easement is the right to enter onto someone's land and use a portion of that land for a specific purpose. Easements may be granted expressly to an individual by deed. An express easement by deed must meet the deed formalities to be valid, including a valid writing and other statute of frauds requirements. Moreover, easements are deemed to be perpetual in nature unless otherwise indicated. Reasonable use/scope. An easement must usually be used reasonably within the scope of the granting instrument, if an express easement. This typically allows the holder of the easement to improve the land where the easement lies and to enter onto it to repair it. Termination. Termination of an easement may occur where the easement is abandoned, where the granting instrument states a specific condition to occur, or where the properties that the easement lies on and the adjacent property holder are merged. Typically, easements are perpetual in nature unless stated otherwise. Transfer of land notice, easement. Generally, when land that is burdened by the easement, the servient estate, transfers title, the easement runs with the land. Thus, even though A transferred the land to Carol C, and then C transferred the land to P, each time the transfer occurred, the easement would automatically run with the land. However, a subsequent bona fide purchaser may attempt to argue that they lacked notice of the easement. If a subsequent bona fide purchaser can do so and state that they did not have notice of the easement, then they can typically defeat an easement holder's title. The goal is to show that the subsequent bona fide purchaser did not have notice of the easement on the land. Recording Act. Under the common law, title in land was measured by first in time, first in right. However, under modern recording acts, people who record their interest in land can preserve their title by putting the world on notice of that interest in the land. There are jurisdictional splits as to what type of recording statute is used, and there are three main ones: race notice, and notice. Race recording statutes are used only in a minority of jurisdictions. Therefore, notice and race notice jurisdictions are typically the most commonly used. Subsequent bona fide purchaser, SBP. In order to actually argue that one did not have notice to the easement, they must be a SBP. Typically, a SBP is someone who took title to land subsequently to the current holder of the land, and they did so for value. Notice and race notice jurisdictions. In a notice jurisdiction and a race notice jurisdiction, the SBP must show that at the time that they took title to the land, they did not have a notice of the competing interest. There are three kinds of notice: inquiry, actual, and constructive. Inquiry notice occurs where the SBP is charged with looking at the property to examine it, and if they had examined it, they may have found the competing interest. Actual notice occurs where the SBP is actually aware of the interest, and recording notice occurs where the competing interest was recorded so that the SBP was on constructive notice via the recording. Race jurisdiction. In a race jurisdiction, the person who records first wins, and that is why it is not used in many jurisdictions, because it often results in unfair outcomes. Shelter rule. Under the shelter rule, a SBP may be able to step into the shoes of a previous grantee and argue that the previous grantee could have validly used a recording in order to defeat a previous claim. The shelter rule may be used despite the fact that a SBP may have had actual knowledge. Sale of land process. At issue is P's claim for breach of contract. When parties convey land, it is a two-step process. First, the parties enter into a contract for the sale of land, and then there is a period of escrow. Following escrow, closing occurs. At closing is where the actual deed is delivered, and at that point the deal is finished. Land sale contract, marketable title. A contract for the sale of land is required to be in a valid writing satisfying the statute of frauds. This express provision essentially was stating that the land would not be sold with any encumbrances on it. An encumbrance is something that includes easements. In every contract for the sale of land, there is the doctrine of marketable title, however. This means that upon closing, the land would not have any defects of title in it, including easements. Therefore, even though the contract stated that the land would not be sold with any encumbrances on it, this would be implied in the contract. Under the merger doctrine, the land contract merges into the deed and cannot be used to provide relief to a buyer. Merger. Under the merger doctrine, the contract is said to merge into the deed, and the buyer may not use the contract to recover for defects on the property. Deed. Deeds contain covenants in them that allow for recovery to a buyer. Whether the buyer can recover depends on the type of deed and covenant contained in a deed. Type of deed. There are three kinds of deed: general warranty deeds, special warranty deeds, and quitclaim deeds. Quitclaim deeds do not provide any relief under a covenant. General warranty deeds provide relief under several different kinds of covenants. Covenant against encumbrances. The covenant against encumbrances states that at closing, there will be no encumbrances on property. This is breached immediately at closing and is considered a present covenant on the property. Remedies. Typically the remedy for a defect in title to land such as occurred here with B's easement is the difference of the value of the land with the easement on it and the value of the land without the easement on it. Overall conclusion. P's cause of action against C for breach of contract would fail under the merger doctrine. Yet P can recover under her deed against C for B's easement on the property, but not W's easement. February 2015. Classify the interest, joint tenants with a right of survivorship. A joint tenancy is a concurrent interest in land in which case at least two individuals own an undivided interest in the whole of the property. A joint tenancy is created with express language that the tenancy carry with it the right of survivorship. The right of survivorship means that when one joint tenant dies, the other co-tenants take the deceased tenant's interest in the property. A joint tenancy is created when four unities are present at the time of creation. These unities are the unities of time, title, interest, and possession. Severance of the joint tenancy. A joint tenancy is severed whenever any one of the four unities of time, title, interest, and possession is disturbed. When one of the four unities of a joint tenancy is disturbed, a tenancy in common results, and the right of survivorship is extinguished. In this event, the tenants in common own an undivided interest in the whole of the property, which is then freely alienable. Recording the interest/recording statute. In a race notice jurisdiction, a subsequent bona fide purchaser, BFP, is protected by the recording statute provided that he takes without notice and is the first to record his interest in the deed. There are three different kinds of notice. There is actual notice, record notice, and inquiry notice. Actual notice refers to the extent to which a BFP actually knows that someone else claims an interest in the land. Record notice refers to the extent to which the BFP is notified by title. And inquiry notice refers to the extent to which a BFP inspects the property and discovers someone else asserting a claim to the property. Additionally, it should be noted that the recording statutes are designed to protect subsequent BFPs and not gratuitous grantees of real property. Determining record notice is a two-step process. First, the BFP must go to county recorder's office, locate the particular property, and construct the chain of title. The chain of title can be constructed by looking first at the grantee index, and then building the chain of title back in time. Next, the BFP must adverse each link of the chain. This is done by looking at the grantor index and following the chain of title until the BFP reaches his interest. Tenancy for years. A tenancy for years is a specific type of tenancy that has a specific start date and a specific end date. A tenancy for years need not be for terms of actual years, but rather only needs a specific starting and ending date. A tenancy for years is terminated upon the end of the specified date. Sublease. A sublease is a legal relationship in a leased property that arises when the tenant conveys out less than his entire interest under the lease. In this circumstance, subleaser has privity of estate with the lessor. Assignment. An assignment occurs when the lessor conveys out all of his durational interest under the lease. In the case of an assignment, the original lessee is no longer in privity of estate with the lessor, but depending on the circumstances may still remain in privity of contract with the lessor. Privity of estate means that two individuals share an interest through their relationship to a leased property, and privity of contract is a contract obligation between two contracting parties. Covenant. A restrictive covenant is a written promise with respect to land either to take an affirmative action or to refrain from taking action. Liability for the restrictive covenant may attach to parties that are either in privity of contract with the lessor or privity of estate. In the event of privity of contract, the contracting party remains liable under a contract theory of recovery. If an express contract between the lessor and the lessee is breached by failing to satisfy the written covenant, then the landlord may sue to evict the tenant and or assert a claim of money damages. Restrictive covenant. A restrictive covenant is a written promise with respect to a particular piece of property to do or to refrain from doing something on that particular property. Restrictive covenants run with the land to successive assignees if the covenant makes the land more beneficial or useful. In order for the burden of a restrictive covenant to apply, there must be intent and notice, the covenant must touch and concern the land, there must be vertical privity and horizontal privity. In order for the benefit of a restrictive covenant to apply, there need only be the elements of intent, touch and concern, and vertical privity. Vertical privity is present when the successor in interest has the entire interest in the property. Horizontal privity refers to the fact that the original parties to the agreement had a mutual interest in the property outside of the covenant agreement. July 2015. Interests in Greenacre. To determine who has what interest in Greenacre, g. the validity and effect of each transfer/agreement must be determined. Generally, property may be transferred by sale, gift, will, or intestate succession. Leases may also create interests in possession of property. Fee simple determinable. A fee simple defeasible is a fee simple interest that may be cut short by a subsequent event. When a fee simple defeasible contains terms of duration, e.g. as long as, for the time that, until, etc., it is a fee simple determinable. A fee simple determinable will be a fee simple until a designated event occurs. Possibility of reverter. The grantor of a fee simple determinable interest retains a possibility of reverter. A possibility of reverter means that fee simple automatically reverts to the grantor at the time the designated event occurs. The grantor need not go to court to claim this interest, the interest automatically vests at the occurrence of the subsequent event. Restraints on alienation. Generally, courts do not allow title instruments/conveyances that absolutely prohibit future transfer of the property. Restraints on alienation may be allowed if the restraint is only conditional/ for a moderate time period, e.g. does not transfer for the next 50 years. However, absolute restraints on alienation are invalid. Any language indicating such absolute restraint will be struck from the instrument, so the resulting interests will remain. Joint tenancy. There are various forms of co-tenancies. Each form allows all co-tenants to possess the whole of the property, though each holds only a lesser, divided share of the property. A tenancy in common is the default form. A joint tenancy carries the additional right of survivorship between joint tenants. This right of survivorship means that when one joint tenant dies, the surviving joint tenant receives the deceased joint tenant's interest in the property automatically, and the deceased tenant's interest is no longer part of her estate, and so cannot be passed through probate. A joint tenancy exists when property is conveyed by an instrument that indicates intent for the property to be held as a joint tenancy with a right of survivorship, and when the four unities of 1. Possession, 2. Interest, 3. Time, and 4. Title exist. Possession. The unity of possession means that all joint tenants have equal right to possess the whole property. Interest. Unity of interest means that each joint tenant must have an equal share interest in the property i.e., for two joint tenants, each must have a 50% interest rather than, example, one having a 40% and one a 60% interest. Time. Unity of time means that each tenant must have acquired her interest in the property at the same time. Title. Unity of title means that each tenant must have acquired her interest in the property by the same instrument. Tenancy in common. When any of the unities for a joint tenancy are broken, the tenancy reverts to a tenancy in common. A tenancy in common is the default form. Under a tenancy in common, each co-tenant has equal right to possess the whole of the property, but only a lesser divided interest in the property. Under a tenancy in common, each tenant may devise her interest in the property, or it will pass through intestate succession, because a tenancy in common has no right of survivorship. Tenancy in common and tenancy by the entirety. Generally, a joint tenant may transfer her interest in the property without the consent of her joint tenants. The effect of the transfer is that it converts the joint tenancy to a tenancy in common, but permission is not required to make the transfer. By contrast, a tenancy by the entirety, which is a joint tenancy held by married spouses, requires that property interest cannot be transferred without consent of the other tenant by the entirety. Leases. There are three kinds of landlord-tenant leases. 1. Tenancy for years, which is a lease for a definite period of time. 2. Periodic tenancy, which is a lease for a definite period, e.g. 1 month, that automatically renews at the end of each period. Or 3. Tenancy at sufferance, which is a tenancy caused by the holdover of property by the tenant after a lease has ended. Generally, rental leases need not be in writing unless they are a lease for years for greater than a 1-year term, because the statute of frauds requires a writing for any contract that cannot be performed within 1 year. Periodic tenancy. A periodic tenancy is created by implication if a tenant pays rent and the landlord accepts at each period. Typically, a periodic tenancy is created at the end of a tenancy for years when the tenant pays rent and the landlord accepts. Rights to third-party rents. Generally, tenants in common each have a right to possess the whole property. So, one tenant may not demand rent from her co-tenant, because the co-tenant possesses the whole of the property exclusively. However, co-tenants may demand accounting for rents received from third parties. Contribution for operating expenses. Generally, tenants in common are not entitled to contribution from other co-tenants for costs expended to repair or improve the property. However, they are entitled to contribution for basic operating expenses which include property taxes. Lateral support. Landowners have a right to the support of the surface of their property. When an adjoining landowner engages in action that causes the adjoining property to subside, the owner who caused the subsidence may be strictly liable for the damage caused. In order for strict liability to apply, the injured party whose property has subsided must show that the actions of the adjoining landowner caused the subsidence, and that the subsidence would have occurred even if no structures were built on the injured party's land. If the subsidence would not have occurred, but for the weight of the structure built on the land, then strict liability will not attach, and the injured party will have to pursue another cause of action to recover. Negligence. Negligence occurs when a party breaches a duty owed to another, and the breach is the actual and proximate cause of damages suffered by another party. Duty. She had a duty to act as a reasonably prudent landowner to the adjacent owners. Foreseeable plaintiff. Under the majority view of Cardozo, a party only owes a duty to foreseeable plaintiffs. Foreseeable plaintiffs are those that reside within the zone of danger of the defendant's actions. Breach. Actual cause. Actual cause is also termed the but-for cause. Proximate cause. Proximate cause is called the legal cause, and the issue is foreseeability. Damages. Damages must be causal, foreseeable, certain, and unavoidable. Zoning ordinances. Zoning ordinances are an effective way for states and localities to regulate the land use of their jurisdiction. However, a person who seeks to violate a zoning ordinance may seek a variance that will be granted or denied in the form of a permit. Variance. A variance is an individual exception to a zoning ordinance. There are two types, area variances and use variances. Area variances are more likely to be granted because it is simply an exception given to allow a building to exist in dimensions that slightly violate the zoning ordinance. Use ordinances are less likely to be granted. A use variance is a permit allowing a person to operate a structure for a purpose that is not permitted by the zoning ordinance. In order to get a use permit, IRA must show that he will 1. Suffer a hardship without the ordinance, 2. That the variance would not damage or harm the neighborhood, and 3. That he is not at fault or a bad actor in his request. Non-conforming use. The other argument that IRA may present is that his operation of the machine shop is a non-conforming use because it was in existence prior to the change of the ordinance. Non-conforming uses that are in effect prior to an ordinance change are allowed to continue unless they cause harm to residents or adjoining property. Even then, an amortization period is generally allowed to allow the owner to find a new location for the activity. Deed of trust. A deed of trust is an arrangement where a third party holds a deed in a trust to stand as collateral for a debt owed. With a deed of trust, if the debtor, IRA, fails to make payments and ends up in default on the loan, the party that made the loan, Jane, can initiate foreclosure and execute a private sale of the property. Mortgage. A mortgage is an arrangement where a party who has or is buying property gets a loan and has the property itself stand as security for the debt. If a debtor fails to make the loan payments and ends up in default, then the holder of the mortgage, the mortgagee, may initiate public foreclosure proceedings against the property. Priority. Upon a foreclosure sale, how proceeds from the sale are distributed is determined by the priority of the creditor's interest. Priority is determined by 1. Whether or not the loan was a purchase money security interest, and 2. When the interest or mortgage was recorded. All purchase money security interests have priority over other creditor interests executed at the same time. However, because Acme had notice of the deed of trust, and because both loans will be considered purchase money security interests, Jane's deed of trust will have priority. Foreclosure. Foreclosure proceeds are not distributed in proportion. When a creditor forecloses on a property and provides notice to any junior interest, at the sale of the property the junior interest is extinguished. Here, Acme initiated the public foreclosure sale, and had Jane's deed of trust been a junior interest, then Jane was required to notice, but her interest would be extinguished at the end of the sale, whether or not she received proceeds. A senior interest remains intact on the property when a junior interest initiates the foreclosure. When a foreclosure is executed, the priority of payment is that 1. All fees are paid for the foreclosure, 2. Senior creditor interests are paid first and in order to the junior interests, and 3. Anything left over is given the debtor or owner of the property. Accordingly, Jane's interest will not be extinguished by the foreclosure sale by Acme. If the proceeds from the sale produce enough to pay both the debts of Acme and Jane, then both will be paid, and any remainder will be given to Ira. If not, Acme's foreclosure sale will be subject to Jane's deed of trust, and the sale will not extinguish that interest. Material breach of lease. Tenancy for fixed term. A fixed-term tenancy is a pre-agreed term by the landlord and tenant. Duty to repair. Generally, a tenant has a duty to keep the premises in good order and repair, unless otherwise agreed to by the parties. The landlord, however, has a duty to repair common areas of use. Implied covenant of quiet enjoyment. A landlord owes a duty of quiet enjoyment to his tenant, including the abatement of nuisances to the extent within his control. A nuisance is something that would be offensive to a person of ordinary sensibilities. Duty to pay rent despite material breach. At common law, a tenant's duty to pay rent is not relieved by the landlord's material breach of lease. Modernly, a material breach of lease that goes to habitability relieves the tenant's obligation to pay rent. Constructive eviction. A landlord owes a duty of quiet enjoyment to his tenant. In the event of a substantial interference with the use and enjoyment of the premises, the tenant may b. give notice to the landlord, and c. leave the premises, thereby being excused from any further obligations under the lease. Breach of warranty of habitability. A landlord of residential property, which includes commercial in California, owes a duty to his tenant to keep the premises fit for normal habitation. This duty is breached when the landlord fails to fix a condition that impacts the habitability of the premises or violates building codes. Remedies for breach of warranty of habitability. When a breach of the warranty of habitability occurs, a tenant has several options. The tenant can a. stay in the premises, deduct rent, and repair the issue, b. stay in the premises and abate rent until the issue is repaired, or c. stop paying rent and move out. Failure to mitigate damages. A landlord has a duty to mitigate his damages in the event of a breach by the tenant. Mitigation as limitation on damages. A landlord has a duty to use reasonable efforts to relet the premises. Damages will be reduced by an amount found that could have been reasonably avoided. Deed requirements. To be valid, a deed conveying real property must 1. Be in writing, 2. Be signed by the grantor, 3. Identify the land to be transferred, 4. Identify the grantee, 5. Contain language of the grantor's present intent to transfer, and 6. Be delivered to and accepted by the grantee. Adverse possession, AP. An individual may acquire ownership of land through AP if 1. Their possession of the land is exclusive, 2. Their possession is continuous for the statutory period, 3. Their possession is hostile, i.e., under a claim of right, and 4. Their possession is open and notorious. Exclusive. To be exclusive, the possession cannot be shared with the rightful owner. Continuous. The facts do not list a statutory AP period, but in most jurisdictions it is between 6 and 20 years. Tacking. Under the rule of tacking, a court would then tack the time of B's possession to S's possession, because he was B's successor in interest. Hostile. To be hostile, the possession must be made under a claim of right. Joint tenancy. A joint tenancy is a form of joint ownership of property. To create a joint tenancy, the tenants must have the unities of possession, interest, time, and title. The deed conveying the property must also state that it is with the right of survivorship. Unity of possession exists when all joint tenants have an equal right to possess the land. Unity of interest means that all joint tenants have the same interest in the land. Unity of time and title require that the joint tenants' interests must have been created at the same time and in the same conveyance. Ouster. A joint tenant's use of property, although usually not hostile to the other joint tenants, may become hostile if the joint tenant denies the other joint tenants access to the land. Severance. A joint tenancy is severed as to a joint tenant whenever that joint tenant conveys his interest to a third party. At that point, the third party becomes a tenant in common. Tenant in common. A tenancy in common requires only unity of possession. A tenant in common is entitled to possession of the premises. However, a tenant in sole possession of the land is required to pay taxes on the land to the extent that the land produces income. Rights and duties of tenants. Joint tenants are all responsible for payment of taxes and entitled to the profits on the land they jointly hold. Partition. Any tenant in common may unilaterally partition the property. Courts prefer a partition in kind as opposed to a forced sale of the property.